Watch this for a second, guys. I'm just grabbing a coffee. All right, I'm here. How is everyone? Hey, Laurie Jean. Hey, Guano. I hope I'm saying that right. Who else do we have in here? Need to go to the back end. Just to make sure I've got you all. So, hi, Mecca and Amber. All right, I've got you all. All right. Hi, Kathy. No worries, Glory Jean. A coffee for you too. All right, we can stop the funny police stuff now. Hi, Friggy. Hi, Ronelle. Thanks for joining us, guys. So, you want me to drink it for you too, Laurie Jean? I think we got a bit of Tom CPU. I think Karen and the family just arrived at the courthouse. So let me just find that for you. I should have already had it ready to go, but I didn't. Okay. Why can't I find their channel? Hang on. Don't know what's wrong. Tom and Boston Mike. Let's say that way about it. There we go. Let's grab. All right. Let's get it on the screen. I'm going to have to go back a bit so you can see the family arriving. Let's go back. There we go. Now, I thought I saw look, there's Scotty McGuinness and I think Esti, maybe to the right over here somewhere. Okay, what's going on in the comments? In Australia, Donovan, it is 1:30 a.m. Hi, Tripping from the UK. Fuzz from the UK. Don't know where Sean's hanging out. Don't really care actually, but all right. Well, I'm just gonna drink it all on you now, Laurie. Hi, Lily. Leapy Lou, Ramblin' Rome. Turtle Boy talked to the parents and Nathan on his live. Yeah. On his live, yes. All right, so I don't know, you're cruising for a modding, Laurie Jean. Be careful. That's not my name from Perth. Hello, Australia. You're up late. Well, actually, no, you're not, are you? You're 3 hours behind me. So it's like 10-ish or something there, isn't it? Hello, Factual Lie. Ozzy, I don't know if you saw Mike's early show, The Young Jacks, last night. He has been truly graceful guide in his lead and insight. I've been watching all of them, Guano. Pet Goldfish, another Australian. Let me see what's going on. I've got the funniest tab open. I literally had to explain to people what a Karen is. Can you believe that? Because I put Karen on the thumbnail of Maddie V's video. And they were like, wait, what? Karen? What's she got to do with this? Hi, Petra from Netherlands. That's my name. 10:30 in WA. That's what I thought it was. Central Queensland, Lily, 12:30 a.m. God, I hope. Dill. Hey, I just realized I got control of this shit tonight. It's actually working. Yeah, I'm not surprised you got kicked out. They probably heard me say something and then booted you. That's not my name. Absolutely. I actually slept for 14 hours after my live stream with Jason. Cherry from North Wales. Ashy Snow, good morning. Laurie has 2 cups in front of her. One for me and one for you. Oh, one for the ex. There you go. All right. Oh, look, I slept so good after Jason's live. So I stayed up pretty much all night for Jason's live. And I hadn't been to bed for 24 hours, I think it was. And then I slept for 15 after that. I was so tired for Jason's live. I was trying not to make it obvious that I was tired, but you know, I slur and, and stuff. The cop daddies were awesome. Good morning, Rita. I might have missed 35. I might have... Oops, I need to plug the lappy in. Quizzy. Hey, girl. All right. Good morning from Canton, Rita. Well, this is a nice little cozy corner over here. Hopefully things don't get too crazy, because I'm driving on my own. Driving the bus solo right now. So we just kind of tuned into Tommy's channel for a bit. There's not really much to listen to, you know. He's always a bit chatty. I don't know why people think I don't sleep. I actually do sleep. I think you just might get that impression because, like, some weeks I've got to push my sleep out so that I can do live streams with Americans on their time, and then I'll swing it around by having a big sleep in. So, like I said, I slept for 14 or 15 hours after Jason's live. Gosh, that was a good sleep. TB asked Mr. and Mrs. Reed for their phones when they arrived at court this morning. Mrs. Reed replied she threw it in the dumpster. It is 1:37 a.m. Laurie Jean. Hi, Loopy. Last breakdown was good. Interesting. He knows Brennan. It is interesting, right? I thought it was. You know what? He doesn't really even know him that good, but I just thought I'd throw it out there, you know, throw him under a bus like he's doing with TV. Why not? I don't know how serious it is, to be honest, but there's always interesting connections behind these folk, isn't there? There's another sand groper in the house. That's right. Loopy's from Western Australia. I love that Ashy. Oh, I missed something. I actually clicked on the wrong thingy. A sand groper, for those who don't know, is a person from Western Australia. I'm not sure what you call me because, like, I'm lifetime. Well, actually, not even lifetime. I'm lifetime all over the freaking place. I've pretty much lived in every state except South Australia and Tasmania. Try and put all of the words together, like sand groper, banana bender, Welshman. We put them all together. Oh, TV must have just said something funny and we missed it. B-Dot. B-Dot's going to join us on a live stream one day. Soon. As soon as I get my shit together. Essentially. He's just waiting for me to get my poop together. But B-Dot's going to join us on a live stream and tell us a bit about the Total Murderer. And because he's had a little personal experience with the Total Murderer. Some of you may not know what I'm talking about. Some OGs here will probably know because I posted it ages ago. A semi-dead iPhone was found on the sidewalk. It was later charged with battery. And there's more to this story, Dill. I'm sure there is. Probably ran out of characters, right?
No, it's not. Setting up like
I know. It's too late. It already came out.
that's what she said.
Oh, we're good. We're good.
Okay. Anyway, I think today will be. She's got a rule on that motion to move the trial. It's been 2 weeks. We still don't know when the trial's going to start.
They both agreed to that, correct?
They both asked for it, but they've also both asked that I not be allowed to be brought up at the trial, and she overruled both of them. So when both sides agree to something, she's sometimes like, "Nah, we're not going to do it that way. We're going to do it the way I want to do it." Okay, Auntie Bev, sorry.
I got a bigger question. Do you think when this is all said and done, right? Karen's found innocent. You're found innocent. They look and see the stuff going on behind the scenes. Do you think that will cause reform in the state of what's happened to Karen Reed and to you? Is that a reform? Like, will this make reform? Will this change Massachusetts in how we do law enforcement? Yeah, it will not, huh?
Who's the next hack up? That's the way it is in Massachusetts. Who's the next hack up? The next, power leads to corruption. Like, it's natural in human history when people have power to want to abuse it. So I'd like to think that it would lead to reform. I mean, it might lead to like a Morrissey no longer being the DA,
right?
And maybe some we got a post commission. Like, the post commission was created to reform the police, but has it? Yeah, I mean, a little bit, I guess.
If they even give the state the data to them.
Right. So that's what I mean. Just like Howie Carr says, it's the hackorama. It never ends. The hackorama is the insatiable thirst that can never be quenched. And so I'd like to think that eventually, if this would light, it has lit a spotlight on it, but at the end of the day, there's more hacks in line. Pigs at the trough.
Right.
That was such a cheesy joke, Dill, that it went over my head.
Well, but you only try, right?
Yeah.
What do we got to lose? We're already kind of in a bad spot.
That's all you can do.
Yeah.
But nothing has ever galvanized the public energy quite like this case because it's so blatant, and it's so. But we'll see. We got a long way to go. We've been doing this for a year and a half at least, and the finish line is in sight, but it's still. The end of Boylston Street. You know what I mean? It's all the way down there.
I know you
keep going.
I know you made like I don't know. You can make 100 reasons why or how Karen didn't do this, right?
By the way, we got some McAllen's coming. No, it's not.
No,
it's
Brennan team. Are the O'Keefe's coming?
Well, we don't know yet.
All right.
Aaron O'Keefe. Yeah, Aaron's coming.
All right.
Yeah, I forget what I was going to ask him.
Is Karen coming today?
I think so.
We hope so.
Yeah. Yeah.
Parents are here.
Kind of the main character,
Yeah.
She wasn't. Her whole family's here.
Yeah, you think Alan Jackson fly in for this?
Somewhere. I don't know.
Look at Meredith. She's such a cute little thing. Who's that walking in with all the cops? Who was that? Cops just lashed out, whoever it was. I think he might. Did you see my thumbnail? AJ's red eye. Hi, Loopy. If the prosecution brings up TB, doesn't that open the door for the FBI investigation into Morrissey as well? I think that the door is already open. I'm pretty sure that door's already open because can't remember how, but it should be one of the motions that we're seeing today. Bev doesn't usually rule from the bench unless she's saying no to the defence. Well, thanks for chatting, Loopy. I hope you find it comfy here. We usually have a pretty friendly chat. Hey, Erica, thanks for joining. Oh, goodness. Here it is, and I haven't even got the sound on. Full cruise there, eh?
Okay. Yep. Talk to like jumping right here in the middle of stuff.
Hey, it's not just women. What?
Yeah, pretty sure she'll shut it. We'll see. That's all
Yeah,
right.
John
Boy,
Senior is the
all security for no ruckus. Isn't that just like a letdown?
Dude,
Like,
who's
it's
in the
never an
queue?
issue. We've never, like, stopped anybody from going in. We've always been cordial, except to Lally. But, like, it's been nice to everybody. Let them go in. We've never booed or been for out. Let them go. But yet we have all these cops to protect what? Like,
There was you
like
hear a
we
pin
would
drop.
stop anything happening to anybody. We're not.
They're afraid of duckies, man. They're there to protect the McAlberts from the duckies. Oh, Jamie, how many times do you need to see the same stream? I was thinking about sharing Young Jerks, but I feel like that'd be a bit rude rather than sending people actually to his channel. So it's probably time to go find it. Let's go have a look, see. Who will we stream? Oh, they got nothing upcoming. Karen Reed, motions hearing today. At 2 a.m. So this one's 10 minutes away. So we'll pop that over here. It's probably going to blast us, but we've got it sitting there. Looks like we're with Law and Crime today, guys. Laurie Jean shouting the coffee. Thank you, ma'am. Thank you for the super sticker. Got to hear all of us. Thank you so much, Kevin, for your preference. Good morning, Kim. Bob, thanks for dropping in. Tara. No, probably not someone else's live. Kind of feel it's a bit rude, you know. I'm probably just going to do the law and crime one. Wow, you got some action going there, girl. Hey, Gilly, thank you for checking in. Another Aussie person in Queensland, Magnetic Island, I think. Is that right, Gilly? Have I got the right one? You want me to stream Melanie? Come to visit. Come to visit where, Kim? I would feel rude if I streamed somebody else and not just send people to the channel and give them the views, if you know what I mean. It's kind of like stealing their viewership. Hi, Petra. It's interesting. Do you think that I think Paul is not behind the murder of his brother, but definitely involved in some of the shenanigans. So I think Paul believes that she did it, and because there's not enough evidence, he's kind of trying to help it along. And then, he's got a stake in it now with this civil case, so he's got incentive to help it along. I mean, somebody definitely fixed John's car, so we think that might have been Paul. That's okay, Tara. You're welcome to join us and watch. We are watching Tom CPU. He's like boots on the ground. He's been filming every single coronary court case since day one. So he's like the most dedicated. He also is at every single court hearing, not just Karen's, TB's, crusty panties, all of them. He's at all of the court hearings. I won't get mad at you. Me and Melanie, we go way back. She probably wouldn't even mind if I streamed. I would just feel rude if I did. That's all. Yes, Petra. I think so, because of the insurance. Because of a lot of things, honest. I think he's just got too many monetary motivations to be helping set her up. So yes, Ashy, he is a warrior. This is the green shirt guy. This is Scotty McGuinness. You guys have heard him yapping on my live streams when I need to just turn the live stream on and go to sleep. He's pretty good for the yak. I think there is cameras in the court today. And it starts in 4 minutes. Oh, look, we're ready. Let's go. Let's go. I don't think there's anything going on in here yet. Yep, thanks, Kevin. I got it. No, Tara, I'm not sick. I've just, it's actually nearly 2 o'clock in the morning, and I've been up all day smoking cigarettes. So I've kind of, got my end of the day happening. Hi, Tanya from Darwin. Thanks for joining us. Okay, what's Darwin? Darwin's 2 hours behind us, so it's like nearly midnight there. Is it 2 hours? I forget now. Hey, Amunra, thanks for joining us. I'm sure I put something up from you before I said hello, but anyway. Glenn. Yes, I'm streaming because I'm up. I mean, hopefully Bev doesn't go all day, because if she goes all day over there in Massachusetts, I'm going to be hectic tired. I'm expecting, an hour or two. Thank you, Tanya. I thought it was somewhere around midnight-ish. Yes, Laurie, I lit up a smoke and then I went. No, there's a few of us out here. We're like shunned by society, but we're still here. I actually think in Australia we're the only ones that hold up the budget, keeps us like out of debt. In Australia, Fridgie, I pay $100 for mine. Real live smokes. So I smoke tobacco, so a 50-gram packet of tobacco is $150 right now. Dude, I so did. But you watch, we won't drop out today. But seriously, I did kung fu fighting with the router.
Checking
It's so dish actually.
2,
4 a.m. in Auckland. Berkey. Ugh. $10 a pack. Jeepers. No, 150 for a 50-gram. Fizzy says a 20-pack, $43. Small packs. No, that's just a 50-gram packet of tobacco. Yeah, it's crazy expensive. We're holding up the Australian budget, aren't we, Quizzy? And my pet goldfish. We are literally the only ones paying like for everything. Backy is €25 in Ireland. Let me do a quick calculation. $38. $39 for 30 grams. $60 for 30 Peter Jacksons. No, you can't, Fridgie, because they check it at the mailing facilities, and then they go, "Oh, this is an illegal importation." The Apple intelligence. Thank you for the super sticker, Bob. Oh, hang on, super chat. Sorry. Yes, Quizzy. Outlawed. It'll be nice when we move out into the island, because there's some people out there that. Shut the front door. When we move to the island, there's actually people there who are allowed to sell, I think, homegrown through the tobacconist scene. Actually, I don't know if they're allowed to. I just know they do. Yes, yes, bacon. It's Mr. Jackson's red eyes. No, it didn't. Talking about on Tom's stream. I'm not sure at the moment. Goldfish. I've got some things getting planned right now, so it won't be too far away. Christmas is going to mess things up like crazy. Like trying to drive on the freeway between here and Brisbane. It's going to suck major, like all the way through Christmas. Is that right, Meat Hook? Oh, interesting, Goldfish. Yeah, stay in touch about that. Looks like Mr. Jackson's red eye is red.
If possible, yes, that would be great.
So this is he in the room? Have we even seen him yet? So I haven't been paying attention. I've been watching the show. Yeah, he's not in the room yet. Dear, oh dear. Yeah, it's not fun, Clizzy. Not at Christmas. Like, I freaking hate driving through the city. I hate it. I stress out. But my son stresses harder, so it's best if I do it. Goldfish, I haven't contacted those people you put me in touch with yet because I've still got so much before I even get to that stage. I've got tons to get before I get to that stage. I hope Jackson's gonna make it on time. Lacey! Woohoo! Thanks for joining. It is morning here, but it's like 2 a.m. Yeah, crazy. Breeze Highways is hysterical through Christmas. So many accidents. Like most of the accidents that happen through Christmas time are on that holiday, aren't they? Oh, I thought he was going to grab him then. Yes, Goldfish. I'm sure they will be. And thanks for putting me onto them. Ugh, I don't think she'll take all day, Loopy. I think this will be over and done with in like, if she's up to her usual tricks, half an hour to an hour. Hi, Countess. It's actually morning here, Countess. It's 2 a.m., so not quite the morning that it is over there. Is that little? It's a little laggy, is it? Let me check connections. Let me get this up. Too much. We're gonna have to wait, boys. It'll only be laggy for a couple of seconds, so give it a couple of seconds. Yes, Bob. Is interesting, isn't it? Not surprising. The phone that drives the internet is flat, so I'm just going to give it a bit of a charge so I can see what's going on. Is it a little less laggy now? Usually, 7 or 8 seconds, sometimes 10 seconds, and then it'll come good. Drilling for oil. excess tea. It's probably only the Australians that'll get that. I don't know. That was only an Australian ad, wasn't it? For Australian peanut butter. Oh yeah, like any one of them on their own are 10 times better, 100 times better. Like, nah, he's way back. He's way the fuck back there. Whoa, back there. What is on the docket? Yeah, it's motions today. So, what were all the motions? Motion for Mr. and Mrs. Reed's stuff. Oh God, the Commonwealth put heaps of motions in, but they were pretty much repeats of the last hearing. So all the stuff that he said he didn't put in from last hearing, he's actually put in again. And then he snapped him off. Yeah, he'll end up going sitting on the other side of the room. Hey, Advantage boys. Advantage boys in the house. I'm guessing Phelps will show feature Sean on the cover. Yep. Probably. The cameraman is?
Okay, perfect. I'll let him
Oh, yeah. I get what you're saying. As soon as I said pulls up the back there, he zoomed in, didn't he? Yes, Kevin, that's on the docket today too, you're right. God, I hope he's not replacing Jackson. He's out of state as well. So it's not going to be replacing Jackson because you can't afford him anymore. It might be replacing him because he's busy. Is that who your nanny's talking? No, that's not who you did. I don't know which one that is. Oh no, you'll have to watch the replay, Jamie. Let me have a closer look at who's who here. Oh, yeah, I think that's Karen's civil attorney just behind him. These two dudes just behind them. I think he is there in relation to Lexus and tech data. Oh, you could be right, Kevin. Yeah, you could be right. No. Yeah, he does, doesn't he, Bob? Hey, Diane, thanks for joining us. I'm just getting a little worried because Jackson's not in the room. And it's 1:15 now. Yeah, it's a bit rude, isn't it, Jamie? I know, Bob. You got to go too. All right. We'll catch up with you later, Bob. Oh, that's who's sitting in the background. One of those dudes behind them. Yeah, he can't actually sit at the table with them until Bev approves him. Is that right? This dude here and this dude here. Who are they? It's probably a good time to be listening to Melanie Little's stream. She probably knows who they are. It's odd they don't have the little mute button on their microphones. Most courtrooms do, but they usually have like a mute button down here. I think Miss Little does. Yes, I was reading that too. Some people aren't confident.
All persons having any business before the Honorable Assembly can only justice in the Norfolk Superior Court in Floyd County of Norfolk. Lord Dan, your e-writings shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
It's 22117, the Commonwealth versus Karen Lee. Can I have counsel identify themselves for the record?
Thank you, Mr. Clerk. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally and also Attorney Laura Moore.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCarthy.
Good morning, Your Honor. Elizabeth.
I've actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Of this criminal nature, he has not.
Farm in the wild, raise animals and harvest crops, make food for yourself and for sale.
We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
Sorry, get that blue ears out. What's he going to do, whinge? We don't want her to have this other lawyer. Wait.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion, similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
Yes.
No.
Yes.
There were two search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The two search warrants from Miss Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there is an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important.
Nope.
The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced an oil and drilled it into
Jim wasted an hour of time.
so it wouldn't swell. Or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. the 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial.
Yes, she hit John's car, you moron.
The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, "In your first discussions," my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it will be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting of her records, and so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Go get him, Miss Little.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy, so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at C.F. McCarthy's. And he wasn't present at the Waterfall on January 29, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. Well, has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed called her father's cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron. was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn.
Provably false.
Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
Tell me how this
In
looks.
between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent at trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of their request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of Lampron. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Lampron is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay. Thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to it's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and/or Metro Court. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
The Commonwealth has filed a motion to reconsider in part, and in addition, there was a request for...
Somebody tell me what the stream's like. I can't tell from this end because it looks pretty clear. It's laggy for goldfish. I just wonder what the others are seeing.
In that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times.
Swan's new Max Ranger 4K security systems have a stronger wireless signal, reaching up to 600.
These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of a defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege, as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not...
I think you're wishing, mate.
that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them.
Oh, here we go.
The most respectful way to pursue those.
It's the Lally story.
The fairest way to pursue those, with moderation, is to get them from Emily Voss in the
We just want to twist her words to make it sound like she's guilty.
In the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on 2 propositions. Number 1, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing.
Dude, you're supposed to be talking about Lampron.
That talks about confidential information as it does confidential informants, and respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that never may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually.
That's her constitutional right.
Evidence to the public or encourage it. It violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the
you're going to twist it.
Of these statements that
That's
have been made.
Consequence.
And so since it is not a confidential informant, it is a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I have never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case. She's in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has
What's
no
unfair is that
bearing
you
on
want
the
to use
analysis in this case.
her constitutional
doesn't.
right to
And so
speak on her own
there
innocence
is
against
a
her.
ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter,
God, I
is a
hate this
witness
guy.
in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
Anybody want Lally back?
Thank you, Your Honor. Robert Birchie for Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor at that time made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided. In any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back, even at the first trial, to come back and request it upon review of the first release?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So Why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay, go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family.
Wait, who's harassing her?
And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. And you said it was a close call.
Maybe she shouldn't have gone and done mushies with Krusty.
Given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corporation's counsel undertook at time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss of a one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they're phrases. They're not complete thoughts. They're more.
What Gretchen Voss wrote is not necessarily what Karen said.
Mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview, if forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case. That this already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called as a witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did, because
on a
she
daily
was not
basis.
on the witness list.
Right, on a daily basis.
I believe so, yes.
Okay.
Every day? Yes.
Okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Wow, she's awfully nice to this guy, isn't she?
And finally, the Commonwealth asks for the first time, for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without.
I'm a smooth talker, and I love a cozy night in. Yellowtail, easy to love.
Communication. I'd ask her would be
Sorry, guys.
willing to
Ads
turn those
really
over
fucking
to me
loud.
off the record, but I asked her we'd be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay,
And that's all I have.
all right. Thank you very much. Mr. Grennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition.
She'll be like, I'll
If you've
take
got
it
the
on
opposition
advisement.
with you, Mr. Grennan?
I have a copy here.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph, the paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
Get your shit together, man. We need to go on a fishing expedition, Your Honour, because we didn't get enough incriminating statements that we can twist around to suit our purposes.
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews the story changes. At one point she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so All I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements, so time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some.
Farm in the wild, raise animals and harvest crops, make food for yourself and for sale.
Pursuing the full force of our proof in every aspect, because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it. None.
All right. Thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add?
No, Your Honor.
Okay. All right. So that is taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so, Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all 3. But do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the 3? There are 3 motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10, Boston.
I'm going to say, look,
And again, on these, Ms. Little, you don't expect to argue. Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25, it's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is, by inference, in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit, supposedly now, another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that that would be the subject matter. It is not a fair conclusion that a person would be
Dude, there's
so
CCTV footage of
fixated
it.
on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually
There you
not the
go.
complete
You just
statement.
got admission that it was repaired.
The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter.
To tell
And during
truth,
that
Hanky
airing,
Panky.
it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all of his statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. Some of the doctrine of completeness. We should know what the entirety of the conversation interview was so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said.
They want the parents
It would be
excluded
impossible
during
at
the
trial
trial.
then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or corroboration, that both sides are aware and know of the substance of
I think
that
I just worked out their game
and
plan
that is the reason we
to take
request
Karen's
the
parents
pleading
out of the
number
courtroom.
400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we can streamline that.
It's not just salacious, Kiki. It's getting her family removed from the courtroom. If they call all her family members as witnesses, they can't sit in the courtroom for the trial and support her. So who's behind this? Who's behind it? The O'Keeffes are behind it. They want her family pulled from the courtroom.
NBC 10. The position is that one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jimmy, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to...
427, Your Honor.
What is 427? 427, yes. All right, so do you want to move on to CVB TV?
Yes.
Okay.
WCVB TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business here. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in case there's objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the conflict. They are the same as the company. They just have a local contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, They are required to obtain them, and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that fifth paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you one, the example of not knowing which door she supposedly saw John Keith go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired on 2020 and Nightline, you hear oftentimes the author of the story, not even the interviewer, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not similar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay. Mr. Albano. Does this have a docket? Does this have a docket number yet? Paragraph 5, it's on page 3. The pages aren't numbered. Actually, you should start at 4. Or why don't you read the whole thing, Mr. Brown? Why don't you have a seat and read it?
I appreciate that. Thank you.
Okay. Paul, do you want me to step off or stay here? We'll stay here.
May I?
Sure.
Thank you. Your Honor, our position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, By having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and jeopardize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not.
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material, so that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them. Case. And that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT which unlike ABC is here.
Why are they all sitting so
does
far
have
apart?
some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17.
Okay, guys, we are going to
scope,
switch over.
Then
come back to this. Pause. Oops. Have you got the link? Do you want me to get the link? Yep. Okay. There we go. But we don't have your sound. Nope, we still don't have your sound. Check in your settings. Check your sound in your settings. Sorry, guys. We'll come back to it in a second. We're just switching the stream over to Goldfish's computer because he's got a better connection and then we'll get a better picture. But just give him a second to sort his sound out.
Can you hear that?
I can hear you, but I can't hear the stream. So check in the browser that you've got your audio shade in the browser. Oh yeah, you should have. Hang on, you should have it. Let me put you down until you sort that out. We don't need to show everyone your settings and shit. Hang on, let's go. Sorry guys, we'll come back in a sec. You might have to, so this sometimes does happen with StreamYard as well. You might have to drop out and refresh and come back. Sorry guys. I'll pop it back on the screen. I'll pop it back up so that you're not missing anything.
information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information, not unpublished information, but I do think that, so I think WBTS and WFXT
Bring you back in.
effectively resolved.
And then drop this.
Do you want to
All right. Whoop. Chuck it back up. Let's go. Nope. Still no sound. Well, that's a bastard. Don't know what's wrong with your sound. I'll pop it back up. It was worth a try. All right. Maybe if you're doing the video and I'm doing the audio, how's that? Because my audio seems to be fine. Pop the video back up again. Can you guys hear it? No, you can't hear it. God damn it, that's not working. It's not working, Goldfish. They can't hear it.
Oh, God damn it. All right.
Damn it, we're worth a try. We're just gonna have to handle a shitty picture. But they're just doing dates and shit now, so it's not like we're missing anything. The joys of being live, exactly. It's fun. So we'll switch back to my shitty audio.
Yeah, I'll see if I can fix it. But yeah, keep going with your stuff. Sorry about that.
That's all right. It was worth a try. Thanks for trying, hey? And we'll see what happens when you come back.
Right, yeah.
All right.
So, okay, let's just.
You're on. You're not on mute, by the way. All right. Let's go back here. Now, I'm just going to take it back a little bit, guys, because you missed a little
Documents
bit.
in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, hers, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC news programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay.
Thank you.
All right. Thank you. So those are all the Rule 17 motions we have. Am I missing anything? Those are all the Rule 17 motions.
You must be boosting our connection.
All right. So we have some housekeeping matters that I just wanted to check on. I still have the motion to continue under advisement. I need to see how we progress for that. The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that, Mr. Brennan? I know you had said you told them that, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they're going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called the chip-on, where they take the chips, the SD card, they reapply it to the boards.
Where'd they get an SD card from?
And they put it in the actual car because there's different software which will give it even a more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this, the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor. I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had sort of like a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the court's specific question about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in the possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I spent it many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I've produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right. There are a couple of issues related to this motion, in addition to the protective order, that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
All right, I haven't read this yet, so I won't know what you're talking about, Mr. Mayor.
So I believe you have read our motion, right? The motion that
I read your motion. I haven't.
Right. So it's just in relation to the motion, Judge.
All right.
So, Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here, or was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan provided this to us this morning.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense
objection
team?
to the parties they would like to share it with, and I understand it's without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used a personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not the emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I believe...
Have they been preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that...
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan ordered conducted or conducted himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or read R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name. But we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, you know, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan, and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Daubert hearing.
That's fair enough. Thank you, Ron.
Does that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion, and I'll continue to do that.
But Jamie, essentially they haven't changed anything. They're still doing Lally's
All right.
bullshit.
So we will see everyone December 12th.
story.
So when do you expect to get me any written material you want me to have prior to the Daubert hearing?
Yeah.
Yes.
Your Honor, we drafted a landing and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here by at the end of the week, so that's great.
Thank you.
And your response by next week, Ms. Giannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay. So I'll give you 10 days?
Thank you.
As long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it as soon as you can get it. All right. Anything else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Mr. Giannetti?
I expect I will, without prejudice.
I have the materials. I'll just wait.
Okay. All right. So if you sign it, then I'll endorse it, Ms. Giannetti. You had it, right? Ms. Little gave it to us just now?
I believe we just gave our copy to the court.
Yes.
All right. So this is the one that needs to be signed, and I'll endorse it. Do you want to take a look at it?
Yes. All set.
Mr. Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
Yes, Your Honor.
You sign that, and I will endorse it.
No, Jamie. Same story. Same trying to use Karen's own words, twisty all against her. Same BS.
Okay. Anything else?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right. Thank you, and I appreciate counsel and the third-party record holders coming in today.
12:9 a.m. All rise for the court, please.
You are muted.
No, we're not. You think we're muted, but we're not. I don't know what your laws are over there. don't know what your laws are over there, Laurie. So, see, Australia's got different laws. They have to hold it for can't remember how long ours is. Data retention laws, Australia. Okay, ours is 7 years. Data retention laws. That's Massachusetts. 3 years. There you go. Massachusetts is 3 years. I'm not going to rant for an hour. I'm just talking with you guys. If you guys keep me here for an hour, then I'll be here for an hour. She's pretty stunning, isn't she? I really hated what a-hole said, you know, oh, you only think she's innocent because she's beautiful. After what he said about Jen McCabe, oh, she's such a lovely soccer mom. It's like, come on, dude. Cuts both ways. You only think Jen McCabe's innocent because she's a soccer mum. We are getting some confirmation that they will most likely, if they do call Bill and I've forgotten the mum's name, Mr. and Mrs. Reed to the stand, they will probably do it first so that they can be in the court for the rest of it. So that'll be nice. The protection order they signed, I think, was like to seal, to impound motions or something. Yeah, no Perry Mason moments here. Yeah, I'm pretty sure that the order was to impound stuff. So, oh, we still got the goldfish here.
I was just watching your stream. I was just sitting here doing my thing.
You're right. Oh, there is something up with your audio.
I think it was.
Yeah, there's a buzzing sound coming through. Quite loud, actually.
Was that the fan? Is it still the fan? Oh, I can't believe it. Oh.
Oh, that was poo. I'm pretty sure Starlink's freaking around with my connection. Hello, am I here? Yes, I think I am. Sorry about that, guys. I think it's time for Starlink to be rebooting their servers and crap. So that's what seems to be going on. Oh my goodness. So can you hear me, Goldfish? Maybe not. All right, so I do have a yup. Okay, you can. All right, cool. We're cool, guys. We're good. Thank you so much for at least trying. Goldfish, much appreciated. I don't know what's wrong with your audio. A few problems there, but if you want to, when I've got a better connection and it's not being stupid, I'll actually hook you up again and we can troubleshoot it or something. Yeah, they basically just read their motions out loud. So, yeah, whatever you did, Goldfish, when you connected to my stream, it sorted everything out. So we should have done it ages ago, but I didn't even look. Hey, I wasn't looking at my Discord messages. When you said email, I was like, wait a second, you don't have my email. So, yeah, I should have looked a little earlier, and somehow you connecting to the stream sorted out the issues. So I don't know what that's about, but all right, so I know, I guess we should do a recap. What was the recap? Okay, this is my prediction. Bev's going to let the media off the hook. That's my prediction with all the media motions. I don't think that she's going to risk an appeal. I think those things actually are appealable. No, it wasn't on Morrissey's phone. She hasn't actually ruled on Morrissey's phone yet. So, but she's obviously getting ready. It could be actually. I think she's getting ready for motions. But whatever it was that was in that document that they signed, I don't think it's been released yet. Yeah, that's exactly it. So yeah, that's my prediction for she can't make a decision from the bench on anything because she has to go run back to Morrissey and ask him for permission. I think the reason she's not ruling from the bench is so she can seal stuff. She can seal everything. So things she doesn't want the public to know, she'll seal. Well, I'm thinking, I'm wondering about that too, Kevin. Like, I kind of feel like something's gonna, like, as soon as Morrissey's stuff comes in, he's the one that's prosecuting Karen Reid. So there's going to be a conflict of interest there. I don't know how that's going to work. They might have to appoint a special DA or something. I don't know. And then if she's implicated in Morrissey's emails, in any ex parte communications with Morrissey, that's going to cause her to have to recuse herself. And because she'll become a witness at that point that she's implicated, she's now a witness. So I think that if she is implicated in any ex parte communications with Morrissey, I actually think that might be the ticket for the feds to step in. Like, as soon as there's public corruption that's provable and not just speculation, I think the feds will jump on it. Yep. We do. We know damn well they were. Yes. See, but here's the thing. She might not have done it in a way that was trackable. She might have been going back to her little dungeon out the back and saying and ringing him and doing it verbally. So it could be, like she was taking all those breaks all the time, and it was just sus, That could be the case. It could be the case. The judge has to take it as true for the purpose of decision making. You could be right. Absolutely could be right. Like, if you're asking for legal opinions, you probably need to go watch a legal channel. So, similar issue came up in the YSL case and the judge recusal, which led to the removal of the judge. Yes. I remember that was something to do with ex parte communications back in the dungeon. I do recall that. So I don't know that it helped them any, but interesting. Interesting indeedy. So yeah, those are my predictions. I don't know if Bill and Janet will get their phones. I don't know if Bev will pass that one through or not. I feel like if it's something to do with Karen herself, she's going to go, yeah. But I don't know if she'll drag Bill and Janet into it. Because I feel like if she does that, she's opening up all the other Rule 17 she's already said no to. So phone communications between everybody else that she's already said no to in the first trial. So it seems to me like she's kind of on a precarious sort of slope here, that if she does let Bill and Janet in, she's kind of sealing her fate for the other motions to come back in. That's what we're hoping too, Jamie. It would be epic, but I don't think they're going to just roll through the door and start arresting people. I think they're going to be following a bunch of motions and things. I don't know. I have to actually watch how they operate, because they're pretty bloody silent. Like, you don't generally know the feds are doing something until they actually are putting the cuffs on someone. So they're actually pretty quiet. Yeah, Kevin, clearly it's absolutely a fishing expedition. Yeah, true. Yeah, we can all hope. Generally, with the feds, you don't really know anything's going on until they are whacking people in cuffs, and I doubt they're going to do it in the courtroom. But oh my god, wouldn't it be spectacular if they just started, like, the feds just like started piling into the courtroom? That would be dope. It absolutely would make a great end to a movie. It would be so dope. Maybe when the movies and docos come out, that's going to be, creative license. Yeah, I want to know that too, Goldfish. There was an SD card in the system. Now, I'm looking at like, I knew that you would have to be able to use an SD card in the infotainment system, because they all got that slot for an SD card. So it's the first time that's ever been mentioned. No, I don't think the maps come on an SD card. I think the maps coming from the internet. Joseph says auto delete does not remove from the cloud. Pretty sure feds have it all. They will not intervene unless life is in danger. Well, their job is corruption, Joseph, so that's when they will intervene, when there's public corruption. Oh my God. We can pray. We could pray for that. They storm the courtroom and whack Auntie Bev in cuffs, and I don't know who else would be in the courtroom, and they drag Jennifer McCabe out by the feet. I don't know. SD card. Let me think about this. Okay, let me look it up. Hang on. Let me look it up. Let's go. LX 570 infotainment SD card location. The micro SD card location. Ah, interesting. Right. Let's chuck it up. Let me chuck it up for you. Show you where the SD card is. Here you go. See those two red arrows? That's a little it's a little cover. So you press that cover and it pops open, and you can stick your little micro SDs in there. That would be a sight to see. We need our taillight expert to look into it. Look into what? What did I miss? Hang on, wait. Taillight expert to look into the micro SD card. Too small for your fat fingers. I think now there's a great ending to a show, like at least to an episode. The SD card is like, say you want to play music on your system or audio, or I think Karen's actually got a screen, so you probably play a movie as well. So it's just like it's like having a thumb drive basically. Because I think it's because they're Texas Instruments. That's not their brand. The brands are all different, but I assume they're going to go to Texas Instruments to get the chip-offs and chip-ons. Actually, that's where Brennan's dude lives, in Texas. That's why they're happening in Texas. What is this? It's an LX 570. So let me just check. Oh, I'm not even looking at an LX. Hang on. I got that screwed up. Give me one sec. SD. Oh no, that came from the Club Lexus website. That was a 2014 model. So hang on. Hey. Hang on. 3 years ago. Hang on, let me share this. You're going to get me struck if you're playing music on. That's the GPS going. God damn it. The tail light guy. I don't know what tail light guy you're talking about. Are you talking about the tail light whisperer? Yeah, that's what I thought too, Kevin. Yeah, that's what I thought. All 8 GB have been uploaded. What more can they get? They can't get any more, Laurie. Tell me if I saw wrong. I thought I saw a speech by Levy about journalist protection, how some are abusing it. Did I get that right? If so, maybe they're going to finally get laws protecting. Look at my last video, Jamie. Levy actually convicted 4 people for harassing journalists. Yeah, you probably could record your stuff to the to the SD card, I'd say. Yep. Well, you know what? I was thinking the same thing, Kevin, except that USB sticks out like a USB stick sticks out of the dash, and it's unlikely that it's going to be one of those. I think SD card's actually more likely because it pushes into the system and into the dashboard, and doesn't stick out. So you did micro SD slot ×2 in the LX50. Yeah, it's where Second picture where? That's not helpful. Micro SD slot. Oh, hang on. Some of the newer models actually do have a navigation SD card. That it can, instead of running the navigation off of the internet, if you have executive trim, it will be the standard sat nav. Hang on. No, that's not the right model. Both are female, connects SD and USB. He did? Some from Lexus. Tiny part unlikely to smash the way it's noted. Hey guys, I got some good news for you. So I got a hang on, let me get the right word for it. I got a PhD hard plastics engineer who wants to talk with us about the likelihood of John's arm smashing that taillight. Would we be interested in that? 2020, I think. Goldfish. 5 dots below the main picture. You haven't even got the page yet before I find the dots. I don't know what page you're looking at, Kevin. You need to tell me what's the top. Posted a link above. Yeah, but you can't post links in here, dude. Hang on, let me look at this other screen. Wait a second. If I go into admin and look, I might be able to see the link that you posted. Give me 1 sec. Hang on. I cannot see your links. Oh my God, we've got to wait for the chat to catch up. Okay, posted a link above. Nope, it's blocked your link. You're welcome, Joseph. Yeah, no, it's blocked your link, Kevin. So you can't really post highlight, copy, and paste. Yeah. Except I can't see it. I mean, you can probably see it, but I can't see it. Nobody can see it. So links are actually blocked in chat by default. So thank you for that, Joseph. Much appreciated. Your insight is always spot on. Thank you from Cambridge. Hang on. Cambridge, Massachusetts or Cambridge, UK? A post-it note with the text, I'll be back. Thanks for that. It's got two. Yeah, that's what I just showed, the first picture. Boo. I know. YouTube sucks. They don't let you have links. I have links turned off in comments, so nobody can do it in comments, but it's done automatically in chat. So only mods can post links in chat. Otherwise, what we end up with is a whole bunch of like you just get hammered with spammers and stuff. Joe Biffle. Yes, it was more gaslighting and covering up. So Hank turns out to be Lally 2.0. I don't know. Are we really missing Lally now? I think Hank's actually easier to listen to, but it's still annoying because of what he's saying. But his voice is easier. Like, I didn't feel like I was going to go to sleep listening to his voice drone on. But it's still frustrating because it's like, It's like, bleh. You can? Hang on. Let me go back and have a look. Oh my God, where's the settings for this? Carryover live ads, third-party tools. Nope. Can you just give me the title on the top of the page so I can Google it, Kevin? If you write exactly what the title is, I should be able to pull up the same page. Hang on. The one thing I haven't done yet is to go to LX. Hey, what happened to 570? Oh, here's the headset. The whole point of the SD card though is it's not built into the system. So Karen has popped it in there herself. No, you're not. You're not a dumbass. I am, because I can't highlight. Oh, shit. Hang on. I can't actually drag over your thingo. I've got to go this way about it to do that. Okay. Okay, let's have a look at what we got. Mark Levinson. It didn't come up. It didn't happen. So here's the point. It doesn't really matter where the card goes. The point is it takes a card. I would rather listen to Robert Shaw drag his fingernails down the chalkboard for 6 weeks than listen to Lowy again. Yep. I'm hearing ya. Ah, there you go. That Cambridge. I gotcha. Yeah, I've got to say I'm not going to miss the what if anythings. Playing media files can be used nowadays to add maps to a GPS system. Yeah. Yeah, so I'm looking at the newer system. You can add more. You can actually do your navigation from the SD card, but it still has to connect to the internet occasionally to be updated. So yeah, that's what I'm thinking too. Absolutely. But anyway, the point being, like, what are they going to get for maps? Nothing, because it's for navigation. It's not where you've been. It's to put a map on the screen so you can go somewhere. What are they going to get from audio like music and movies? Certainly no timestamps or where she was that night. So the SD card's freaking useless. But also there's a component, since we are so far into the stream and we've just got a select few on here, I'm going to show you something. Let me see if I can find. I'm going to show you a little something. It's not something I really want to publish because I'm waiting to see if it's useful to someone, but let me have a look. So there's a chip. There's a chip that the defense want to look at. Sorry, the Commonwealth wants to pull this other chip. It's called a S29JL064J. It's a spansion chip. SPANSO. Yeah. Okay, so the tech heads in the room are going to understand what I'm going to say here, and that's about it. It's not a data chip. So you remember Hank said there's like a lunchbox and it's got 3 motherboards in it, and each of those has a chip on it. So he's thinking there's 3 chips that he can extract info from. However, one of those chips is the spansion chip, and it's a CMOS. It is not a data chip. So Hanky Panky's a dickhead. A dickhead. So yeah, for those who actually understand what a CMOS is, let me pop it on the screen. I'm not going to show too much detail because I don't know if it's handy for the prosecution or not, so I'm trying not to show too much detail. But there you go. See, spansion, there's the model, and see, it's a CMOS. That's all you need to know. Correct. That's right, Kevin. So they aren't going to find anything there. Take my word for it. There's nothing there. Well, there's plenty there. It's just nothing useful to them. There's not going to be any GPS data or timestamps or blah, blah, blah. The best they're going to get is the last time the system was updated. Correct, Kevin. I'm trying not to put too much information out there because I don't know if it's useful. You know, it's always nice to have a secret little left hook when you understand, when you're actually in trial. So I don't want to actually go too far out. Hey, Stephen, thanks for joining us. Afternoon your time, 4:30 in the morning my time. There's no there. Correctamundo. There is no there. So, yeah. This leads me to believe that Hank is not a tech head. Okay, first of all, Hank had no idea what he was saying about the bits and bytes. He was just given a spiel. Here's an excuse to say that, which didn't actually make any sense. Yeah, I don't want to spill too much. And then, secondly, he doesn't understand what a CMOS chip is. So, what? But, I'm trying not to, like, I wanted to get excited about it, but I thought, you know what? I probably should tell the defense first. So, like, in a roundabout way, I think I got the message through to them. I don't have contact with them, by the way. Sometimes I post things on X publicly and tag them, but this one I kind of had to go through the back door and out into the yard and across the creek and jump a few fences. But I think I got it to them. We'll see. Yeah, I do some lives occasionally, Stephen. Not all the time. Like, Abby tells me I've got to stick to 2 a week. That hasn't actually been working out. Some weeks I'm doing like 3 or 4, and other weeks I'm doing none. But she also tells me I've got to stick to an hour, and I don't think I've ever managed a single stream under an hour. But oh well. It gives me something to cut up through the week. So hang on. Sorry. I got something in my throat. If I do, like, I don't know, I did a 6-hour stream the other night, but that gave me 6 1-hour videos to chop it all up and upload through the week. So I didn't actually have to think of any content creation for a week. So that was nice, having a holiday. But that's generally what I try. I'm trying to do that with my live streams, like pack a heap in and then cut it up into smaller, more manageable bits for people who don't have time to watch a 6-hour live stream. I don't need them to explain them to me, dude. I kind of looked them up and I got an idea what they're doing. I know what they are and I know what they're doing. Once you got a model number, you pretty much got what you need. Once you got a brand and model number, how is the build going? The build is going freaking slow. I'll tell you what I am. I am $2,000 short of the dunny. It's all I got left. So I think I got, like 2 more paydays and I'll have the dunny. Something like that. 2 or 3 paydays. Oh, I had so much fun with that guy. Is so dumb. He was so easy to smack down. Like, seriously, the shit that comes out of his mouth, it's crazy. Oh wow, that's keen. A bit of binge watching. Good on ya. I like a binge watcher. I do a bit of binge watching myself. Like, if I can't sleep, I will just sit. I'll just go and rack up like a YouTube channel that I like, and I'll just play everything all the way through till I fall asleep, and then I'll wake up 6 hours later and it's still playing. How did I find the case? Well, I have been in the true crime genre for a couple of years, but I kind of put it down for a bit. Like, I had a break for about probably a year. So what I started out doing was just showing people in true crime, like, tricky crap that the other creators do that make you think they've got evidence of something and they don't. So that's kind of where I started, just like exposing the trickery of the other creators. And then I did a couple of takedown bids of that McDonough dude. So not the Sean McDonough dude, the Chris McDonough dude. Did a couple of takedowns of his rubbish. And then I stopped for a while. Like, a whole bunch of BS went down everyone, like, I don't know, everyone went weird. So I was like, yeah, I'm out. And then, but I still watch true crime. I'm still a true crime junkie. So even when I wasn't actually doing anything with my channel, I'm still watching, everything else that's going on. And so I saw, what did I see first? I saw Larry, DUI guy, do an interview with Turtle Boy. That was the first thing that I saw. And I was like, wait, they're jailing people over this case? So my first sort of fleeting knowledge of the case was actually, I think, Law and Crime or Court TV or something did a brief, oh, they've got the video proving that she done it, that kind of thing. But then I heard, I think it was DUI guy, might have been someone else before that actually, because I think DUI guy came into it after Turtle Boy had been jailed. Like, it was before that. It was someone else someone else who interviewed him before that. And I was like, wow, this is getting really deep. Like, if protesters are getting jailed for this shit. So yeah, that's when I really started paying attention, when all that stuff started happening. The protesters got arrested or whatever, and Total Boy as well. And I was like, that's how you can tell when there's corruption going down. When protesters and journalists are starting to get arrested and shit. So yeah. Okay, Laurie, thank you for joining us. Go feed your fur babies. Thanks for joining us, and thanks for the 2 coffees. So yeah, that's the story how I found the case, essentially. I just forget who it was that interviewed Turtle Boy the first time. It has to be one of the law tubers, because they're the ones I watch the most. So fill in the blanks. Dude, it's like so hard to keep up with what goes on X sometimes. And like, a lot of it's just rubbish. Like, I'm sure the people involved in it think it's very interesting. But a lot of it is just rubbish. So, I mean, I can show you some examples, like the amount of rubbish that's going on. Let me go. Let's find what's the rubbish that's going on today. All right. Absolutely. I'm glad I did too. You know how you guys mostly discovered me? I actually wasn't getting into the recommendations. I wasn't getting anywhere. I had 1,000 people, 1,000 subs when I came back to YouTube. And you know what happened? Melanie Little shouted me out. And then the Glare shouted me out. And then Turtle Boy shouted me out. And then Mike shouted me out. So everybody's kind of helped grow my channel, just shouting me out all the time. So so I do owe, I owe my existence to them. I owe my my toilet and my couple of packets of screws. Let me share this screen. Here's the stuff I save you guys from. So apparently there's a bunch of people having a meltdown over the Defence Fund event. I don't know why. I didn't get involved in it. Yep. There's meltdowns about that. Okay, there's all this Phelps stuff going on. Phelps manager's losing the plot, man. He's like, off his freaking dial. Like, you think Sean's... Check out that photo. Do you know who that is? Yes. Melanie Melanie started it. She kicked it off. Exactly. You found me through Mikey? Yeah, he's a cool dude, Mikey. So do you guys know who these two are? I'm pretty sure Glenn knows who they are, but I don't know if anybody else knows who they are. And some of you might actually like freak out when you find out who the guy on the left is, because nobody ever gets to see his face. He's very elusive when there's cameras around, this guy. Have I lost you all or what? Or are you still trying to think who it is? Anybody? One of them's the Clara. So the one with the beard is the Clara. And the other person is none other than Microdots. The Micro Dizzle. That's right. The shizzle, the dizzle. But didn't come out right, but you got the picture. Anyway, here's Rich Bestein telling us about that. I put that in my video tonight, so that was pretty funny. Oh my god, these people keep ending up with new accounts. Pearl Clutcher. Oh my god, she kissed somebody. Oh, that makes her a murderer. The shock and horror. So these guys are really annoying. Like, every month they all switch their accounts. They all sign up for new accounts, and it doesn't matter how many times you block them, they come back. They're like chlamydia. It just keeps coming back. I'm not sure if chlamydia does, to be honest. You get what I'm trying to say, right? There's actually not as much drama on here right now as there was this afternoon. It's actually settled right down. I mean, there was some crazy drama before I started this live stream. Oh, there you go. That one's that's always going on. She finally got her ass tossed. They're very abusive people. There you go. That's who tossed her ass. LV cops. See, it was their doing. Oh, this drama queen. Oh my god, she's always freaking every day's a new drama with this bitch. Like, serious. Yes, exactly. Yes, Kevin. It's a great big game of whack-a-mole. Nuts. Yeah, right. I'm trying not to actually get involved in this sort of shit. This is just slapping back and forth. Like, Haley gets right into it. Haley slaps him back and exposes him, does all sorts of stuff. Haley's always going off. That's probably why I see a lot of it. But if I just shut, hang on. Okay, so this is someone I've blocked. It's arguing with Biff the Thunder Muffin. Dear Biff. Phelps. I think that's KP and Lindsay. And then Chrissy. Oh my God. Chrissy's got a whole bunch of dramas always going on her wall as well. With everybody. Ever since she came out on our channel, she's actually come all the way around to thinking Karen actually is innocent and that everyone is trying to frame her. I don't know how far around, but I think she's almost there. Yes. They're getting real nasty because they've lost their power. It's getting real nasty. And that's why I don't show it to you guys, because it is. Yes. She was. Come out. Huh? Come out? What? I don't know what you're talking about. Sorry. Hello, fellow attorney. Hello, fellow attorney. I'll gladly accept your apology for correctly pointing out that I am incompetent. Thanks, moron Matt. Haley's got some good comebacks. I haven't seen you guys this far apart since you both sent messages about Lindsay not wanting to see Dr. Turtleboy the week of December 21st. So they're actually disagreeing with each other quite a bit. This one is pray for poor Meredith. And she's like, no, F you, F Meredith. And then, oh yeah, apparently Lindsay was not interested in seeing Turtleboy at all that week, except Donna. She wants a threesome. Anyway. That's kind of one of Haley's usual sort of posts on X. She cracks me up. Good on you, Larry Legend. Allegedly. I'm sure Maddie B always wanted to end up in a meme. I'm just not sure that's what he was thinking of. Use your real name, you Twitter tough guy, for the pussy that turns off comments on Twitter and doesn't understand the basic premise of con law. Exactly. You sure sound tough. Sorry you got hurt by the internet, loser. I don't know. Haley's nowhere near as witty as that when I've got when I've got him on my channel live stream, he's nowhere near that witty. But yeah, he has some pretty good takedowns. I guess most of us miss where you called out Aidan Carney for posting a photo of LG's toddler on a Pornhub ad. Listen up, you effing moron. Not a single person has shown that Aidan Carney did a damn thing regarding that defunct Twitter account beyond Lindsay making the allegation. I think we got proof that Lindsay actually made that account, haven't we? Hang on, where was I? It's entirely likely that Lindsay herself made that account, given what we know about her. Unlike the situation I'm posting about, while I agree it was wrong for a picture of her and her child, I don't know. This is a big rant, guys. The original post that I was talking about in my tweet was a post from making fun of Aidan by an account who isn't a fan of his. Unlike you and your assertions of me, my principles aren't dictated by what tribe. Also, every post you make isn't about pornography and kids. You could have simply ignored my tweet. Be a good person, you absolute loser. Loser. I really didn't feel like it was too big a rant. Didn't feel like reading it all. See what I mean? These people cannot keep child and R out of the same freaking sentence every time. If I didn't have them all blocked, I could show you. But it's disgusting. They cannot post a single thing without child and porn in the same freaking sentence. They're just stuck in this world. And none of us are even thinking about any of that shit. They come up with freaking every time. Every time. And if you have a look at all Maddie's insults with Total Boy, he's doing it now too. It's like all the freaking time. It's every time. They just can't keep kids and porn out of their freaking heads. It's really sad and it's sick. Okay, I don't even know who this one is. Can't stop, won't stop. I don't know who that is, but anyway, I'm not sure what you think you know, but given your extensive experience in court, you should know if you're going to make some kind of baseless allegations about me, you're way off base. Oh, he's swatting. He's swatting flies. How Western crooked. So anyway. Oh yeah. Should I have given you the jump scare warning? I really don't understand why these people cannot type a sentence on X that doesn't put children in compromising positions. It's crap. It just shows you their mentality of where their brain's at, that they can't disconnect the two. They can't just have you can have a dig at someone, that's fine. Have a dig at someone, but stop bringing kids into it. Dig without kids. Try that. How's that sound? What do you reckon, guys? Can you hear the kookaburras? Might be a little too far away. is telling me that the sun's coming up. Which is my bedtime. I'm a vampire. They're obtuse. Oh man, they're more than obtuse. It's like, it's disgusting. It's really disgusting the way they talk about kids on there, especially Lindsay's kids. They're awful. None of us mention Lindsay's kids. I guess a couple of people say, you know, those poor kids, it's been stuck in the house with her. But that's it. As far as, you know, kids and sexuality in the same sentence, there's no need for it. Sure, you want to stab someone in the eyeball, but what are you using kids for? Like, that's the caliber of person that they are, that they think it's okay to use a kid in a sentence where they're stabbing someone else in the eyeball. You know, as far as I'm concerned, that's almost as reprehensible. In fact, it is more reprehensible than using Karen to stab someone in the eyeball. Ridiculous. All right, guys. Yes, the kookaburras are saying, Ozzy, it's time for you to go to bed to sleep all day like a vampire. Okay. Appreciate everybody coming in and having a bit of fun on the live stream with me and watching the trial with me. Much love, guys. Yeah, for some reason, it's pretty sick, right? For some reason. All right. Kookaburras are kookaburra-ring. Good night, everyone. Talk to you on the next stream. Bye.